So Donald Trump just got slapped with a court order so devastating that his own lawyers are scrambling to completely overhaul their entire legal strategy. And honestly, this happened right in the middle of a hearing. We're talking about a federal judge who didn't just reject Trump's arguments, she systematically dismantled them, point by point, in real time, while Trump's legal team watched their carefully constructed defense crumble before their eyes. It's honestly hard to believe we're watching a former president's legal strategy collapse this spectacularly in open court. This isn't just about one case or one ruling. We're talking about a decision that could fundamentally reshape how Trump approaches every single legal battle he's facing. And trust me, there are a lot of them. The implications are staggering, the legal reasoning is ironclad, and Trump's team knows they just walked into a courtroom ambush they never saw coming. Let me fill you in on what's been happening because this story goes way deeper than you might think. So, Donald Trump and his legal team have been fighting tooth and nail against Jack Smith's federal election interference case. This case, brought by special counsel Jack Smith back in August 2023, charges Trump with conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an official proceeding, and conspiracy against rights. These are serious federal charges stemming from Trump's efforts to overturn the 2020 election results. From the very beginning, Trump's strategy has been crystal clear. Delay, delay, delay. His lawyers have filed motion after motion, appealed every ruling they could, and tried every procedural trick in the book to push this trial past the 2024 election. The thinking was simple. If Trump could just run out the clock, win the presidency again, and get back into the White House, he could make these federal charges disappear. He could fire Jack Smith, shut down the prosecution, or even pardon himself. That's been the entire playbook. Whether it was claiming absolute presidential immunity, arguing that he can't be prosecuted for official acts, or trying to get the case dismissed on technical grounds, Trump's legal team really cemented themselves as masters of procedural warfare. They've been playing the long game, banking everything on delay tactics, working long enough to save their client. But here's where things get wild. Enter Judge Tanya Chutkan, the federal district court judge overseeing this case. She's been assigned to this case since it was filed, and she's made it abundantly clear from day one that she's not interested in playing games. She's rejected delay tactics before, she's pushed for trial dates that would happen before the election, and she's been consistently firm about moving this case forward regardless of Trump's political calendar. Reports from around October 28th revealed just how frustrated Judge Chutkan was becoming with Trump's legal maneuvering. During a critical hearing that day, she didn't just voice concerns, she issued a ruling from the bench that sent shockwaves through the courtroom. She labeled Trump's latest immunity claims as constitutionally indefensible, and even went as far as to say his arguments fundamentally misunderstand the nature of presidential power. Talk about strong words. Essentially, Judge Chutkan was calling Trump's legal theory dangerous, not sticking to the constitutional framework that limits executive power. And this wasn't a private conversation. Judge Chutkan made sure to deliver this ruling in open court in front of reporters, cameras, and the public, making it clear that she was not impressed with Trump's arguments. This announcement sent shockwaves through Trump's legal team because it raised all sorts of questions. If Judge Chutkan, the person with direct control over this case's timeline, could shut down their primary defense strategy so decisively, what did that mean for everyone else scrambling to keep Trump out of a courtroom before November 2024? Now, this isn't the first time we've seen this pattern with Trump and the courts. Trump's relationship with judges and legal accountability really only extends to whether they help him or hurt him. Whenever a judge rules against him or doesn't bend to his will, he's quick to attack them, undermine them, or claim the system is rigged. We've spotted this pattern time and time again. Just think about how he turned on Judge Emmett Sullivan right after Sullivan refused to immediately dismiss the Michael Flynn case. Trump went after Sullivan publicly, claimed he was biased, and his supporters launched campaigns to discredit the judge. The entire episode showed Trump's playbook. When a judge doesn't give him what he wants, attack their credibility and paint yourself as the victim of a corrupt system. Then there was Judge Amy Berman Jackson. Trump wasn't pleased when Jackson presided over cases involving Roger Stone and Paul Manafort. When Jackson imposed a gag order on Stone for his inflammatory social media posts, Trump and his allies went on the offensive. They questioned her impartiality, suggested she was politically motivated, and Trump himself made thinly veiled suggestions that these judges were part of a deep state conspiracy against him. And let's not forget how he distanced himself from the judges who ruled against him in the classified documents case. Initially, when judges would deny his motions or rule against his legal theories, Trump would immediately claim they were Obama appointees or Biden appointees. as if the president who nominated a judge automatically determines how they rule on the law. It's a pattern designed to undermine judicial independence and prime his supporters to reject any ruling that goes against him. Even judges who were appointed by Republican presidents have faced similar treatment when they ruled based on the law rather than Trump's preferences. Multiple Trump appointed judges have ruled against him in election cases, January 6 cases, and other legal matters, and each time, Trump's response has been to suggest they were weak, disloyal, or compromised. Now, it looks like Judge Tanya Chutkan is in the hot seat. This pattern is becoming all too familiar. You can be a federal judge with an impeccable record, follow the law precisely, and rule based on constitutional principles every single day. But the moment you don't give Trump what he wants or cease to be useful to his delay strategy, he'll attack your credibility and paint you as part of a corrupt system without a second thought. So, what did Trump's legal team do to trigger this devastating courtroom rebuke from Judge Chutkan? Well, it all boils down to presidential immunity. The impasse happened because Trump's lawyers wanted the court to accept a sweeping theory of absolute presidential immunity, essentially arguing that a president cannot be prosecuted for any actions taken while in office, no matter how criminal. While Jack Smith and the prosecution were trying to move forward with a trial based on the principle that no one is above the law. Ultimately, the case has been stuck in legal limbo for months since no one was willing to budge on this fundamental question. As the defendant's legal representative, Trump's lawyers decided to take an aggressive, maximalist stance. They filed motion after motion arguing for absolute immunity, refused to accept any narrower interpretation, and pushed the issue all the way to the Supreme Court. Their approach seemed to be just run out the clock by creating as many legal hurdles as possible, knowing that every appeal and every motion buys Trump more time. At first, Trump seemed to be somewhat on board with this idea. He appreciates aggressive legal tactics, and the notion of claiming he's being persecuted by a weaponized justice system plays well with his political base. But here's where things started to go wrong. But as the immunity claims dragged through multiple court levels over several months, some serious issues started cropping up. The Supreme Court's July 2024 ruling on presidential immunity was narrower than Trump hoped. The trial date kept getting pushed but not eliminated, and Judge Chutkan was signaling increasing impatience with the delay tactics, while Trump's lawyers were steadfast and holding their ground on immunity arguments. Predictably, the public and legal community began to shift their frustration toward Trump's side. Polls indicated that Americans were increasingly viewing Trump's legal maneuvers as cynical attempts to avoid accountability rather than principled constitutional stands. Multiple surveys showed majorities believing Trump was trying to delay trials for political reasons, rather than defending legitimate legal principles. This was the moment Trump began to sweat a little. You see, Trump values winning public perception and overall maintaining the appearance of strength. He doesn't want to be tied to a legal strategy that is transparently failing and making him look weak, scared, or guilty. That's definitely not the victory he seeks. And then his lawyers went ahead and made a move that, according to Trump's political instincts, was a serious misstep. Trump's legal team started looking for ways to relitigate the immunity question after the Supreme Court remanded the case and figured they should present even more aggressive arguments to Judge Chutkan about what constitutes official acts deserving immunity. They even considered arguing that Trump's entire pressure campaign on state officials, the fake electors scheme, and his January 6 conduct were all official presidential acts. But then, when Judge Chutkan heard these arguments during the October 28th hearing, she absolutely lost it. In Judge Chutkan's eyes, these arguments weren't just legally weak, they were constitutionally dangerous. Claiming that a president trying to overturn an election through fraud and intimidation counts as official acts, that's pure constitutional nonsense. Any legal theory that would give a president immunity for attempting to subvert democratic elections is instantly labeled a threat to the constitutional order. Here's where it gets interesting. Judge Chutkan didn't just reject the arguments, she eviscerated them with a level of detail and force that stunned everyone in the courtroom. According to reports from Politico, published on October 29th, Judge Chutkan stated from the bench that the defendant's interpretation of presidential immunity would place the president above the law in a manner wholly inconsistent with our constitutional structure. She went further, noting that if accepted, this theory would allow a president to commit crimes with impunity so long as they could claim some connection to their official duties. She characterized the legal theory as an existential threat to democratic accountability and said the arguments presented bordered on frivolous given the Supreme Court's actual ruling. Now, this left Trump's legal team in a tight spot. On one side, they really need to maintain their aggressive defense, strategy to satisfy Trump personally and keep up the appearance of fighting hard. The MAGA base will be disappointed if Trump's lawyers appear to be conceding anything or backing down from the immunity fight. Trump himself has made it clear he expects his lawyers to fight on every front, never give an inch, and create maximum delay. On the flip side, they actually have to practice law in front of a federal judge who has now made it crystal clear she views their current strategy as legally meritless and potentially sanctionable. That means figuring out how to defend Trump effectively, maintain credibility with the court, and avoid professional consequences for advancing frivolous arguments. The tricky part is all of that requires some level of legal restraint and acknowledgement of the court's authority, both things Trump hates. So Trump's lawyers are caught in a bind. They can either keep pushing the maximalist immunity arguments to please Trump, which means facing potential sanctions from Judge Chutkan, losing all credibility with the court, and setting themselves up for devastating appellate rulings. And that only makes the eventual trial more likely and paints Trump's defense as desperate and legally bankrupt, or they can do their actual job as officers of the court, which means moderating their claims and accepting some limitations on the immunity defense and focusing on factual defenses rather than sweeping legal theories. But that'll definitely make Trump turn against them for appearing weak or not fighting hard enough. It's a tough situation, and that's the mess Trump creates for his own lawyers. He demands complete loyalty and wants them to make arguments that have no legal merit without any strategic retreat. But then he blames them and fires them when those arguments fail spectacularly. He's not shy about tossing his legal teams under the bus whenever it suits him, and several of his previous lawyers have found themselves in legal jeopardy precisely because they followed Trump's instructions too faithfully. This whole scenario is causing major stress within Trump's broader legal and political team. If Judge Chutkan has shut down the primary immunity defense so forcefully and is willing to publicly call the arguments constitutionally indefensible, every Trump advisor is left wondering what the backup plan actually is. Those more moderate voices on Trump's team are trying to balance legal reality with Trump's political demands and are now worried sick about heading into a trial with a defense strategy that the judge has already called meritless. They know that pursuing a defense the judge views as frivolous could lead to sanctions, could prejudice the jury against Trump, and could result in harsher sentencing if convicted. Meanwhile, the Trump loyalists who believe the entire prosecution is a political witch hunt and that Trump should never concede anything are doubling down. They believe the lawyers aren't aggressive enough and that Trump should be willing to attack Judge Chutkan personally, accuse her of bias, and make this case entirely about persecution rather than legal merits. Things became even more intense when Boris Epshteyn, one of Trump's most loyal political advisors and a key figure in Trump's legal strategy coordination, reportedly broke away from the cautious approach recommended by Trump's lead attorneys. According to multiple sources speaking to CNN in early November, Epstein had been pushing for even more aggressive attacks on Judge Chutkan personally and criticized the legal team for not being confrontational enough in their filings and courtroom behavior. He reportedly argued that Trump should be treating this case as pure political theater rather than trying to win on legal merits, since the legal merits were always going to favor the prosecution. When someone as aligned with Trump's most combative instincts as Epstein starts creating internal conflict with the actual lawyers trying to navigate the case, the strategy is falling apart. Now, let me tell you, the legal community's response to this hearing has been remarkable. Jack Smith and the prosecution team decided to press their advantage immediately. Within days of Judge Chutkan's October 28th ruling, according to court filings reported by MSNBC, Smith filed a motion requesting the court proceed directly to trial preparation and set a firm trial date. He pointed out that Trump's immunity arguments had now been addressed by both the Supreme Court and Judge Chutkan, that further delays would only serve Trump's political interests rather than any legitimate legal purpose, and that the public interest in timely justice demanded moving forward. The prosecution's motion was aggressive in its language, stating that the defendant has exhausted his immunity defenses and the court has definitively rejected his constitutional theories. Further delay would constitute an abuse of the judicial process and deny the American people their right to see justice served before the upcoming election. The prosecution also highlighted that every day of delay allows Trump to continue his public attacks on the judicial process, to fundraise off claims of persecution, and to potentially intimidate witnesses or influence the jury pool. They argued this created an urgent need for the court to move swiftly. The legal process moved pretty quickly from that point, and Judge Chutkan recognized the urgency. After all, every day this case remains unresolved means the constitutional questions at its heart go unanswered. The public remains divided about whether Trump attempted to overturn an election, and the possibility grows that Trump could use electoral victory to shut down his own prosecution. On November 2nd, according to court documents reviewed by CBS News, Judge Chutkan issued a scheduling order that was a major blow for Trump's delay strategy. The judge declared that Trump's immunity defenses were exhausted as a matter of law, that further litigation of claims the Supreme Court and this court have already rejected constitutes dilatory tactics, inconsistent with the defendant's obligations under the federal rules of criminal procedure. That's legal speak for saying you've got no solid ground to stand on here, you're just trying to run out the clock, you're abusing the judicial process. But Judge Chutkan went even further. She set a firm trial date of March 4th, 2024, exactly one day before Super Tuesday, when multiple states hold their presidential primaries. The timing was deliberate and sent a clear message. Despite Trump's political calendar, despite his presidential campaign, despite his obvious preference to delay until after the election, this trial would proceed on the court's schedule, not Trump's. The order also included strict deadlines for all pretrial motions, limited the scope of what could be relitigated, and warned both parties that further dilatory tactics would result in sanctions. Judge Chutkan calling out Trump's strategy by name created a real stir. It's a significant move, reminding Trump that he isn't above the rule of law or immune to judicial authority. This is a huge deal that doesn't usually happen in functioning democracies. A former president being told by a federal judge that his legal defense strategy constitutes an abuse of the judicial process. Legal experts are noting that we haven't seen a federal judge so directly and forcefully reject a former president's legal claims since the Watergate era. Andrew McCarthy, a former federal prosecutor and contributing editor at National Review, is definitely not some liberal partisan. Went on Fox News and made a statement that really should catch everyone's attention. He said that if these are the arguments Trump's team is making, and if Judge Chutkan's characterization of them is accurate, they're going to have a nearly impossible time defending this case at trial. You can't build a defense on constitutional theories that have been definitively rejected by both the Supreme Court and the trial court. And at some point, you need a factual defense, and I haven't seen one emerge. Just think about that for a moment. A conservative legal expert on Fox News is essentially saying Trump's legal strategy is failing and his defense looks impossible. And this is coming from someone who it's been sympathetic to Trump on other legal issues in the past. Laurence Tribe, a constitutional law professor at Harvard with decades of experience, mentioned that Judge Chutkan's ruling represents one of the most important rejections of executive overreach in modern American history. The theory Trump's lawyers advanced would have fundamentally altered our constitutional structure by placing the president above the law when legal. Experts from both sides of the political spectrum start using terms like constitutionally indefensible and existential threat to democratic accountability. That's the moment to really pay attention. So let's break down what this courtroom showdown could mean, because it's not just a captivating legal story. It has serious consequences for how our democratic system and judicial independence operate. First up is the immediate political fallout. Trump is already facing significant backlash due to his 4 concurrent criminal indictments, and his approval ratings among independent voters are taking a hit. Republican primary voters remain loyal, but general election polling shows concerns about Trump's legal troubles affecting his viability. The March 4th trial date means Trump will potentially be sitting in a federal courtroom during the most critical phase of the presidential primary season, and honestly, that's not the best look for him. Most folks in America have a good deal of respect for the judicial system as a vital part of our constitutional framework, even if they don't always agree with specific rulings or individual judges. Watching a presidential candidate defend himself against federal charges of trying to overturn an election during the primaries creates a powerful visual that reinforces the prosecution's narrative. Democrats and anti-Trump Republicans are definitely planning to take advantage of this situation. They'll argue that Trump believes he's above the law and does not hold the Constitution in high regard, and they'll have Judge Chutkan's actual ruling backing up those claims. This is going to be Exhibit A in proving that Trump represents a unique threat to constitutional governance. You can expect to see clips from this hearing, excerpts from Judge Chutkan's ruling, and images of Trump in the defendant's chair popping up in Democratic campaign ads, speeches, and debates from now through November 2024. The Lincoln Project and other anti-Trump conservative groups are already preparing materials highlighting Trump's legal jeopardy and connecting it to his unfitness for office. Now, let's touch on what this means for the federal judiciary itself. Chief Justice John Roberts has been working hard to keep the Supreme Court out of partisan political battles, wanting it to be viewed as above partisan influence and focused on legal principles rather than political outcomes. But by issuing a narrow immunity ruling that Trump's lawyers then tried to expand beyond recognition, Roberts inadvertently waded the court into this controversy. Trump and his supporters are now poised to attack the entire federal judiciary, implying that judges from the district court level through the Supreme Court are biased against him and questioning their motives, and this complicates things for the judiciary's image as a neutral arbiter of constitutional questions. Yet Judge Chutkan probably felt she had no other choice. If she stayed silent, while Trump's lawyers advanced legally frivolous arguments designed purely to delay the trial, the court's credibility would take an even bigger hit. She had to draw a line and make clear that the federal courts won't be manipulated by delay tactics disguised as constitutional arguments. This situation shines a massive spotlight on the principle of equal justice under law. At the heart of the issue is whether a former president can simply delay, obstruct, and manipulate the legal system whenever he faces accountability for alleged crimes. If he gets his way on that, it could totally change how our criminal justice system operates for future presidents. For 250 years in American democracy, the foundational principle has been that no one is above the law. Presidents are subject to criminal prosecution after leaving office. The legal process doesn't pause because someone decides to run for office again. The courts operate on their own schedule based on the interests of justice, not the political calendar. This system was designed this way specifically to prevent presidents from using their office, their political power, or their campaign schedules as shields against accountability. But Trump has always been uncomfortable with those limitations. He craves total control over every situation, including the legal system that's supposed to hold him accountable. If Judge Chutkan had allowed Trump to delay this trial indefinitely by relitigating immunity questions the Supreme Court already addressed, that's a significant boost to executive power above judicial authority, and it opens the door for future presidents to misuse that precedent. Imagine a future president accused of serious crimes claiming they can to be tried because they're running for re-election or because they might win and the prosecution would be inconvenient. That's the slippery slope Judge Chutkan was determined to avoid. So the implications of this ruling reach far beyond just Trump and Jack Smith. It's about shaping the structure of constitutional accountability for many years to come. Each time Trump brushes aside judicial rulings, attacks judges who rule against him, or advances legally frivolous arguments to delay accountability, it weakens our constitutional system. It starts making behavior that used to be completely unacceptable feel normal. Think about it. If Trump can attack a federal judge's integrity for ruling based on the law and half the country accepts that as normal political behavior, what's to stop the next president from doing the same? If he can claim absolute immunity for criminal conduct connected to official duties, and millions of Americans believe that, it's a legitimate constitutional theory. What's to prevent another authoritarian-minded leader from following that lead? These actions don't just disappear when Trump leaves office or when this case concludes. They become part of our political and legal culture, the new baseline from which future conflicts begin, and that's pretty dangerous. Democracy relies on norms, institutions, and shared commitment to constitutional principles. Assuming that people in power will respect judicial independence and accept legal accountability, even when it's politically inconvenient, when those norms crumble through constant attack and partisan defense of norm-breaking, democracy itself starts to falter. We're watching in real time whether our institutions are strong enough to hold or whether a sufficiently shameless political figure can simply overwhelm them through relentless pressure. Looking ahead to November 2024, it's clear that all of this is going to have some significant effects. We're still almost a year out from those elections, but the narrative being set now is bound to influence how things go. If the story playing out is one of Trump battling every institution, from federal judges to the Supreme Court to the entire justice system, and coming out on the losing side at every turn, that spells trouble for his campaign. Voters usually don't reward chaos, constant legal battles, and defiance of judicial authority. They want stability, competence, and leaders who respect American institutions. Right now, Trump isn't offering either of those. His legal strategy is in shambles. His immunity defense has been rejected at every level, and he's facing the prospect of sitting through a criminal trial at the height of the presidential primary season. So expect Democrats to champion a message focused on restoring normalcy, respecting the rule of law, and moving past the Trump era's constant constitutional crises. After years of chaos under Trump, from 2 impeachments to January 6 to 4 criminal indictments, there are folks who believe that if you vote for Democrats or even certain Republicans willing to oppose Trump, the country will actually start functioning normally again. They're promising no more daily constitutional emergencies, no more attacks on judges and the justice system, no more questions about whether a president will accept election results or obey court orders, just good old normal democratic governance. That message might just hit home for a lot of voters, including some moderate Republicans and independents who are exhausted by the drama. So here's the deal. A federal judge just dismantled Trump's entire legal defense strategy in open court and set a trial date that could determine the 2024 election outcome. This isn't just one bad day in court for Trump or a minor legal setback his team can appeal away. It's a fundamental rejection of his claim to be above the law. If Trump's immunity arguments fail completely and he stands trial before the election for attempting to overturn the 2020 results, then we're basically saying that presidential accountability still exists in America and that our constitutional system can still hold even powerful political figures to account. That would mean we still have a functioning democracy where courts can check executive power, but if Trump successfully delays and attacks the judge until she's forced to recuse or wins the election and shuts down his own prosecution, then we're stepping into a completely new realm where political power and shamelessness can overwhelm legal accountability. It's about so much more than just whether Donald Trump goes to trial. It's about whether we genuinely have a constitutional system where the rule of law applies equally to everyone, or if we're just stuck with a system where whoever can generate enough political pressure and public chaos can escape accountability indefinitely. So keep an eye on this. Things are just heating up. The next few months are going to be absolutely crucial. Judge Chutkan has drawn her line. Trump's lawyers are scrambling to find a new strategy, and Jack Smith is pressing his advantage. The stakes have never been higher, the constitutional principles more clearly tested, and the outcome more unpredictable. This is history unfolding in real time, and what happens in that courtroom will echo through American democracy for generations